Yeah, so evening everyone. Like Haley said, I'm James Brown. I work at the practice as well. What I'm going to be speaking about today is EHC plans and everything in between. And like Haley said, that is a very broad topic to try and fit into a webinar, but I will do my best. So what I'm going to be looking at is EHC Needs Assessment requests, so how you go about obtaining an EHC plan, what an EHC plan should look like when you get one, how it should be set out, and what level of specification it requires to be valid, the different schools that you can have named in a EHC plan funded by local authority, what happens if it doesn't go to plan, for example. So if you get to a point where you've got a bad decision from your local authority, so SEN Tribunal Appeals, for example. And then I'm going to try and cover everything in between, which is the very broad point. But what I've tried to do in the PowerPoint is look for the most common problems I come across when speaking to you as parents on a daily basis. And I can tell from the questions that have been sent in advance that a lot of the problems I have listed as the everything in between, they are the questions that you're kind of asking. So I hope it will answer all of the questions for you. But of course, if your question doesn't feel like it's been answered, obviously put it in the Q&A box. So just a please note point, this is a general PowerPoint. It is not specific legal advice. Whilst the law is clearly set out, it is not specific to your circumstances. So please don't rely on it as legal advice. You would need to seek further legal advice if you're unsure on anything. So to kick off with this, so the first point is looking about how to obtain an EHC plan. So there will be many of you watching tonight that may have an EHC plan, but there are also a number of you watching, and I know this from the questions that have been asked, that don't have an EHC plan right now, and you're very much at the beginning of the process. So the first step is to look at how you can go about obtaining an EHC plan. Now, the answer to that is looking to make a request for an EHC Needs Assessment to your local authority. And you would make an EHC Needs Assessment request under Section 36, subsection 8 of the Children and Families Act. Now, what an EHC Needs Assessment is your local authority carrying out an assessment of your child or the young person and working out what your child's needs are and whether that necessitates for an EHC plan to be made for your child. So that's very much the first stage to looking for an EHC plan, is making a formal request to your local authority directly. Now, it's very important that you are aware that any parent, young person or school can request an EHC Needs Assessment. What is important is it does not need to be the school who requests this. Now, I've seen a lot of parents come to me and say, well, my school said they didn't have time to make the request, so we didn't go ahead with it. But we're now wondering whether or not we should do. And the answer is always yes. You don't need to wait for the school to make the request. And you're very much well advised to do the request as soon as you possibly can, because of the timescales involved. The local authority has 6 weeks to come back to you. So if you're pretty clear that an EHC plan is going to be needed for your child, or that you think an EHC Needs Assessment is definitely required to find out that answer, you really should make that request as soon as you can, and you don't need the schools back in to do that. Just an important point in relation to COVID, because obviously we're now living in a COVID world. Hopefully that will be finished soon. But for the time being, and whilst COVID is still around, at the time of speaking, there is no delay on EHC Needs Assessments being considered by the local authority. So if you do send a request into your local authority, despite what is going on in the world, the local authority will still need to consider EHC Needs Assessment requests and provide you with an answer to those. That's a very first point about that. The second point is looking at what the legislation actually says about EHC Needs Assessment and the legal test that you would need to satisfy in order to have an EHC Needs Assessment carried out for your child. Now, that is under Section 36(8) of the Children and Families Act again, and that says that local authority must secure an EHC Needs Assessment if the authority is of the opinion that A, the child or young person has or may have special educational needs, and B, it may be necessary for special educational provision to be made for the child or young person. Now, looking at that test, there is no definitive answers that are required at this point, which is important. It is a relatively low threshold of a test. It is a balance of probabilities that your child may have special educational needs and it may be necessary for special educational provision to be made. You do not have to prove definitively at this stage that the answers to both of those are yes for the local authority to go ahead with this assessment. Now, the key aspects of that test, as you can see in bold and underline, is special educational needs, special educational provision, and what is necessary. So looking at special educational needs, that is defined in section 20 of the Children and Families Act, which states a child or young person has special educational needs if they have a learning difficulty or disability which calls for special educational provision to be made. Now, that's usually quite clear cut at that point, but often it can be slightly confusing to parents. And there's also subsection 2, which is a child or compulsory school age or a young person has a learning difficulty or disability if they have significant greater difficulty in learning from the majority of the same age, or has a disability which prevents or hinders from making use of facilities generally provided for the same age in mainstream schools. So that is the very much definition of what disability, what a special educational need is, and you would need to look at that and apply that to your child. Now, of course, in a lot of instances, it's quite clear to you. So, for example, a dyslexia diagnosis would be a special educational need, as would a autism diagnosis, for example. You would be well within section 20 of that definition. Looking at what special educational provision is, and that's in section 21 of the Children and Families Act, which says educational training provision that is additional to or different from that made generally for others to the same age in mainstream settings. Worth noting also is subsection 5 of section 21, which says healthcare provision or social care provision which educates or trains a child or young person is to be treated as special educational provision. Now, that is a very wide definition of special educational provision, and when you are considering what your child may or may not need in terms of provision, you need to really look at that definition and apply that, because local authorities may try and divert you and say, well, actually, that's healthcare, that's social services, for example, go take it up with them, not your educational team. Now, if there is any educational or training element to any healthcare provision or social care provision, then that will be special education provision. And a recent example I had of that with a tribunal actually at the start of this year was with a child with diabetes, and she had diabetes which had a massive impact on her ability to attend and engage in lessons. But the local authority was saying to the parent, this is all health provision, all she needs is a healthcare plan, and the school should just take care of her. But in fact, what she did need was actually dedicated full-time one-to-one support in the classroom, and also to help her catch up when she was missing learning. So we were successful in the tribunal in actually getting an EHC plan for that. So you really need to look at your child's needs on a sort of factual basis, and not be put off by any local authority myths or anything like that, which may try and sway you from applying for an EHC plan, because the definition is quite wide in that respect in terms of special educational provision. So the next point to look at within the legal test is the word necessary. Now, that is not defined in the legislation like special education provision is, for example. You have to look for the case law. So the word necessary falls somewhere between really useful and essential. What is necessary is a matter to be deduced rather than defined. Its determination will vary according to the circumstances of the particular case. And the most recent case on the point on necessary is what is necessary is an evaluative judgment based upon the specific facts of the particular case, which are for the specialist tribunal to deduce. So looking at that, you have to really apply the circumstances of your child's needs on a very individual basis. There is no set right or wrong answer here for what is necessary. It very much falls down to what is necessary for your child. So again, if the local authority are trying to put you off with any sort of policies, for example, which says what is necessary, well, again, you can be pretty safe with the knowledge of the case law, which says, well, that needs to be decided on the individual needs of my child, not what a local authority policy is, for example. Now, looking at how you go about submitting a request for an EHC Needs Assessment, and the parents I speak to are always quite concerned about this, and as to what may constitute a valid request and what they need to submit, for example. So if we're looking at what the legislation says, there is no requirement to submit any evidence with your request for an EHC Needs Assessment, for example. A one-page letter could constitute a valid request. Now, I'm not saying that's appropriate in every situation. However, you do not need to submit every single document you have in relation to your child's special educational needs when applying for an EHC Needs Assessment, and sometimes it will be to your advantage not to do so. There is also no requirement to submit the EHC Needs Assessment form, which your local authority will have on their website and will ask you to complete, for example. You don't have to fill that out. And often parents will say to me, well, a lot of these boxes don't apply to my child. What am I meant to put here? And the answer is, well, you don't have to put anything. There is no requirement for you to fill out that form. And like I said, you could pen your own letter rather than using the local authority's EHC Needs Assessment form on the website. And it's important to consider any evidence you have at the time of submitting your request and whether this actually assists. The temptation is to submit everything you have, but it may not be helpful to do so. Remember, you need to target your evidence you submit with your request around the legal test. That is what you need to pass. It's not anything other than that. It's just that evidence. So, for example, if you had an educational psychologist report already in your possession, which said, yes, your child needs an EHC plan, then yes, I would probably submit that to local authority. However, if you have evidence which suggests, well, we're not really sure about an EHC plan, actually your child's needs may, in our view, be met better elsewhere without an EHC plan, for example, you might want to consider whether or not you would want to share that information at the start of the EHC Needs Assessment process, for example, because you're under no duty to provide that to local authority. What is an additional point also on that point is that often parents may serve reams and reams of evidence to try and support the application, and actually might just serve too much, because you've got to appreciate that's going to land on a local authority's caseworker's desk, and they're going to have to make a decision on that paperwork, or it's going to go to their panel members to decide on the EHC plan, for example. And if you have too much, you might just blind it too much in terms of what your child's needs are and what the provision is. So I would always be quite cautious on what you are submitting at that stage. A lot of times we'll hear school teachers or SENCOs or head teachers or even LA officers say to parents that there is not sufficient evidence to submit your request, and like I've just set out, it can put parents off making the request, but you've just got to remember that there is no requirement for evidence at this stage. Like I say, a one-page letter can be a valid request for you. Looking at some false information that local authorities are giving parents out there at this moment in time, and a lot of myths that are out there, because local authorities do so. I mean, statistically speaking, 1 in 4 EHC Needs Assessment requests will be turned down. When you consider a low threshold test, that's quite surprising if the local authority were applying this properly. So you need to think what myths are out there, what misinformation is out there from local authorities. And so, for example, we don't recognise independent educational psychologist reports. We only accept NHS LA ones. That is unlawful for local authorities to do so, and they should be considering all the evidence that is before them. And for example, if you did have to go to the SEN Tribunal, they would afford them the same weight. Any child who does not need 12.5 hours of support is not entitled to an EHC plan. Like I say, it's wrong. That's wrong. The test is Section 36 of the Children and Families Act. And there is no threshold or hourly threshold for support that constitutes an EHC Needs Assessment being required or at that stage. So a lot of children may not actually need one-to-one support. It could be a different provision they require, which does not necessarily mean they have to satisfy any hourly threshold. So it's just plain wrong. But local authorities do like to throw that out at parents. Another point is that social care, or that is healthcare, which I've touched on already with the example given. But again, you would look at Section 21 of the Children and Families Act, which extends the definition of special educational provision, of course. The final example is that your child has to be X number of years behind your peers, or for example, your child is making academic progress, they're in line with what other peers are doing, so why would an EHC plan be necessary? And again, that's wrong. It's the individual needs of the child, and the code of practice, the SEND code of practice, is actually helpful on this point, because at paragraph 6.23 it sets out that progress is not the whole picture, and the whole child's needs has to be included. So whilst your child may be making academic progress, for example, or maybe achieving to what their expected level is, there may be other issues going on in the background, such as mental health difficulties, social interaction difficulties, speech and language difficulties, for example. So it's got to be the full picture, not just applying a blanket policy on these things. So that's looking at the sort of legal test for an EHC plan. And like I say, that you would really just apply the legislation. You don't be misguided by any local authority myths or any policies they may have. Like I said earlier, the local authority has 6 weeks to make a decision on this request. And if the answer is no, you have a right to appeal to the SEN Tribunal, and that right of appeal will last 2 months. But for example, if the local authority do agree with your request, at 16 weeks from the date of your request, they will have to decide if they will issue an EHC plan for your child or not. Now, if the answer is no, again, you have a right of appeal to the SEN Tribunal. Following that, if, for example, local authority do issue the EHC plan, they don't push you to an appeal, you will then get a finalised EHC plan within 20 weeks of the date of your request. So when you look at that, you need to be aware of the timescales, of course, because if you're sitting there thinking, well, I need to wait to see if I can get this evidence before I make my request, or I need to wait for my school to get all their evidence in line before I make my request, what you are doing is going to delay that process quite significantly. So, and you have to bear in mind that ultimately you may have to appeal one of these decisions. So it's not potentially just the 20 weeks decision, your 20 weeks timetable you're playing with. You have to consider the tribunal timetable as well. So really time is of the essence of making these requests to ensure you can keep these timescales to a minimum. What I would also say is that you need to be aware of those timescales to make sure that local authorities do not miss them. Because I have seen time and time again with parents where they come to us and they say, well, we did apply for a request, but we just haven't heard back from the local authority. And well, actually that is unlawful, and the local authority cannot miss any of these deadlines. And if they were to do so, you have quite an easy way to resolve that, which is through a way of pre-action protocol letter, which I will come on to in a bit more detail towards the end of the webinar. But it's really important to be aware of those timescales to make sure the local authority don't miss them and ultimately delay getting the provision in place for your child. So now, turning to the contents of an EHC plan, so let's assume that your local authority has said, yes, we'll issue an EHC plan, or you've been to a tribunal appeal and you've now got an EHC plan in place for your child. This is what it's going to look like in its most basic form, because it's a 12-section document ranging from Section A to Section K. But what I would say, I'm not going to go through in detail all of those sections because it would take a long time to do so. But what I am going to do is go through the key sections and the sections that you need to focus on when you're looking at your child's EHC plan, and when you're coming to review your child's EHC plan as to whether or not it's working for your child, and as to whether or not that provision is appropriate still. So the key sections are Section B, which is the special educational needs of your child or young person. Section F is then the next important section, which is the special educational provision for that child, which is needed to meet those needs. And then Section I is the educational placement, so the school named in Section I of the plan, which is going to meet all of the needs for your child and deliver that provision, for example. Now, they are the key sections because they are the legally enforceable sections. Because if you get your EHC plan and you're unhappy with it, you can go to the SEN Tribunal and appeal those sections and have them rewritten, for example. You can, by way of case law, also look at Section E outcomes. And you can now also look, since 2018, at requests for recommendations to be put into the healthcare and social care sections, which are Sections C, D, G, H1 and H2. But for the purpose of this webinar, I'm going to focus on Sections B, F and I. So looking at your EHC plan when you get it, like I say, they are the legally binding sections, Sections B, F and I. So Section B is the equivalent of a medical diagnosis, and Section F is the prescription to meet all the needs diagnosed. So the two very much interlink with each other. And Section B is key here because, as you'll see with the case law and the code of practice, it is held that provision must be specified for each and every need specified in Section B. So therefore, if Section B does not contain an accurate description of your child's needs, Section F is ultimately going to be light on provision. Now, a common problem that I see with parents when I speak with parents, when I look at EHC plans for them, is that Section B will be incredibly short and they will miss key diagnosis. For example, you will see, I've seen plenty of children's EHC plan where they have complex special educational needs with severe autism, for example, and you would expect Section B to really set that out to be clear to the reader of the EHC plan. However, Section B doesn't even contain a reference to the diagnosis of autism, for example. So already there, when you can see that as an example, you can see that Section F is likely to be light on that provision because there's not an accurate description in Section B. So it's really key to look at the whole of the EHC plan there with Section B and F to make sure they are working together. What is then going to happen with Section I is that it must be then capable of making the provision set out within Section F of the plan. So you would be looking at what the provision is, and then you would be looking at suitable schools and saying, can they deliver that provision? If the answer is yes, then they would be a suitable school to be named in Section I of the EHC plan. Turning more to what happens in reality with EHC plans, and like I say, they are usually, when they are made by local authorities, they are usually void of any meaningful detail and lack the specificity and quantification required of EHC plans, and often they will have gone against your preferred placement option and they will have named their choice of school in Section I. By that I mean a local authority would have done. So that's what you're dealing with, and that's why you really need to look at the plan carefully, because all of the section must be specific, detailed and quantified, and none more important so in Section F of the plan. So a lack of specificity comprises the legal enforceability. So if your EHC plan is lacking in specificity and it's not clear what provisions should be provided to your child, then you're going to have difficulties trying to enforce it. So it's really key to look at the EHC plan in detail there. Looking at what specificity is, Children and Families Act 2014 requires EHC plans to be specific. The SEND regulations support that, and the Code of Practice supports it at 9.69, and it actually helpfully sets out what specific should look like. Now, the case law also supports that, and there's the old case of Ellen Clark and Somerset, which says that specifics should be so clear that it leaves no room for doubt as to what has been decided and what is needed in the individual case. Now, there was a further recent case issued on Monday of this week, and that is the London Borough of Redbridge and HO. And that is the most recent decision on specificity, and it sets out the number of considerations the tribunal will make when they are considering specificity in the plan. But what it has confirmed still is that contents of an EHC plan have to be specific and quantified as is necessary and appropriate. The tribunal will then have to consider what is practical in the circumstances. So that it's very still clear that EHC plans have to have a high level of specificity and quantification still. Looking at some examples of some real EHC plans to really sort of look for you as parents, so you can look out at your EHC plan when you get it, or you may want to go and look at your EHC plan after this webinar, for example. I'm just going to run through some examples of some unspecified and unquantified provision, which would be ringing alarm bells for me if I was looking at an EHC plan for a parent. So the first one is referral is required for X to the NHS Speech and Language Therapy Service. Now, that is not specific and quantified provision for an EHC plan. A referral to the NHS Speech and Language Therapy Service may happen. The NHS Speech and Language Therapy Service may turn around and say simply, we've looked at the papers, there's nothing we can do, we're not going to help. Now, the local authority has satisfied their duty as per that wording just by making that referral. So with speech and language therapy, you would be looking at specific and quantified recommendations rather than any referral, which may ultimately lead to no provision being made for your child. What should have happened is that what speech and language therapy is required should have been clearly set out already by the local authority in the EHC Needs Assessment. So a speech and language therapist assessment should have took place then. Another example is access to one-to-one support when needed. Again, that does not provide the specific amount of hours that one-to-one support is needed for, who decides when it's needed, for example, and when will it actually be provided. If, for example, the school can't actually deliver that one-to-one support when it is needed, then you're going to have difficulties trying to enforce that. So the one-to-one support should be set out clearly in terms of hours, for example, and it should be clear as to when that support is needed. So, for example, is it needed in break and lunch times? If so, that should be specified. Another example is X would benefit from access to a specialist dyslexia teacher throughout the school year. And again, benefit from is not specific wording for an EHC plan. We could all benefit from something, but that does not say your child necessarily needs it. And also access to a specialist dyslexia teacher does not guarantee any specialist dyslexia input. For example, your school could simply ring up the specialist dyslexia teacher and say, we need to do this, we need to do that, but then the dyslexia teacher just simply gives advice over the phone. that would be sufficient for the purpose of that wording in section F of the plan. And you would be looking for whether or not that needs to be direct input with your child, for example. So there's a lot of examples to go through. I'm not going to go through all of them, but they are all examples which are not sufficiently specified for an EHC plan. And again, if I was looking at an EHC plan, I would be advising that those recommendations need to be changed. Looking at some good examples for me, real EHC plans. So these are the EHC plans that I've worked on and often have to go through the tribunal process to look this way. But for example, in relation to the one-to-one support point, full-time one-to-one support throughout the school day, including break and lunch times, from a teaching assistant with experience in training and working with children with ASD and speech and language difficulties. Now that is a specified provision in a plan. It is clear that the full-time one-to-one support has to be throughout the school day, including break and lunch times, and it's from a teaching assistant with experience in training with children with ASD and speech and language difficulties. So the experience is clear, and the level of support throughout the school day is also specified. Looking at the speech and language therapist example, X requires 1 60-minute session of speech and language therapy per week with a HCPC registered speech and language therapist with experience in working with children with specific learning difficulties and severe speech difficulties. And again, that is very clear for the purpose of an EHC plan, that what level of speech and language therapist your child will receive, and it sets out clearly. So then, therefore, if the local authority did not provide that, you would be able to enforce it because it is very clear as to what should be provided. Now, these examples come from expert reports and usually from independent expert reports, which I will come on to in a bit more detail, but ultimately these are the recommendations they make. A lot of the bad examples, for example, were from local authority and NHS reports, which don't necessarily contain the level of specification and quantification required for an EHC plan to make it enforceable. So that's looking at what the EHC plan should look like in a little bit of detail and what you should be looking out for in section F. In terms of the provision you can ask for as parents, that goes from anything from placement in a different year group, which may be very relevant with the impact of COVID and the amount of learning that children are now missing, class sizes, small group sizes, length and frequency of sessions, one-to-one work, psychiatric input is capable of being educational provision, the program content, duration and frequency of delivery, and skill mix to deliver must also be specified and put into an EHC plan. And also parents cannot be required to make educational provision. Now, there are a lot more examples of what can go into an EHC plan. There are just some. And for example, a waking day curriculum could go into an EHC plan. Residential provision could go into an EHC plan, for example. That's not a sort of be all and end all list of provision for an EHC plan, but it is just a good example of what you can have in the EHC plan you have for your child and what you can request goes into it. And it's important that any of that provision that does go into the plan is specified as set out on the previous slide. And looking at the final point running through the content of the EHC plan. So once you get your EHC plan, you've got a draft copy of it. What you're going to get is the opportunity to put forward your choice of school to local authority. Now, under Section 38 of the Children and Families Act, the local authority is required to consult the parent about the draft plan, and it gives you the entitlement to request a local authority to name your chosen school or other institution to be named in the plan. Under Section 38, subsection 3, parents can request a maintained school or nursery and academy, further education college or non-maintained school, special school, and colleges registered under Section 41 of the Children and Families Act. Now, Section 41 of the Children and Families Act is a list of schools, independent schools, specialist schools that have been approved by the Secretary of State to be named in Section I of the EHC plan. Now, you can still request totally independent schools to be named in Section I of your EHC plan. The local authority will still have to consider those requests. But what will happen with the Section 38 duty is that under Section 39 of the Children and Families Act for those schools, it requires the local authority must secure the plan names the school or other institution requested by the parent, unless A, the school is unsuitable, or B, the school requested is incompatible with the provision of efficient education for others or the efficient use of resources. Now, they are two exceptions, and the local authority have quite a bit of discretion to try and use them. But for example, when you're looking at schools, you need to be looking as to whether or not the school you're putting forward is going to be suitable, whether there is any impact on the education of others in that school. The primary point at looking at that is that school full. Is it going to have any impact on putting an additional child in that classroom, for example? And the efficient use of resources obviously comes down to cost. And now I would say from experience, when you start putting forward Section 41 registered school, the most common response you're going to get from your local authority is that it's an inefficient use of resources and the provision costs too much and they can do it cheaper elsewhere. Now, of course, if that does happen when they finalise the EHC plan, you have a right of appeal against that decision. But if you can target your evidence outside of the appeal whilst you are requiring the local authority to consult those schools and you have evidence to support that it's not inefficient use of resources, and you can prove that the school is suitable, then you would want to do that to try and avoid the local authority naming a different school. But in reality, the local authority is the decision maker here, and if they do not believe that your child needs that level of provision at this stage, then they are unlikely to name it based on the efficient use of resources. Looking specifically at mainstream schools, so if you want your child to stay in a mainstream education and you want your child to be educated with his peers, for example, in a mainstream setting, then you have a right, you have a parental right for that to happen. And that is under Section 33 of the Children and Families Act, which gives you a right for your child to be educated in a mainstream setting. Now, the only exception to that happening is if A, it's against your wishes to do so, but of course that would not apply if you were requesting a mainstream school setting. And the only other exception is it goes against the efficient education of other children. Now that is a very high threshold for the local authority to try and use when they would be trying to deny you naming a mainstream school in Section I of your EHC plan, because the local authority are under a duty to remove any incompatibility. So they've got to do all in their power that they can to try and remove that incompatibility to the best of their ability. So in reality, where that would apply is in limited circumstances. So you do have a very strong right for mainstream education to be named in Section I of the plan. Your child's placement cost at the mainstream setting does not come into it. So if a certain level of provision costs too much, and the local authority says, well, we could do that cheaper in a special school, for example, Section 33 gives you a veto on that, and you can simply say no, and the local authority in compliance with Section 33 would not be able to name that special school in the plan. Just a final point on Section I, which is contained at Section 61 of the Children and Families Act, which provides that the local authority can arrange education to be otherwise than at school. Often you'll see it shortened to EOTAS, and that basically provides that your child could be educated at home, for example, and given a home education. Now, you would not be too concerned about what Section I says at this point, because you would be looking and focusing on what Section F provides, because it's really important for an EOTAS package that everything your child needs to be educated at home is specified in Section F of the plan. And for example, the Section I of the EHC plan is not going to name your home in Section I because it cannot do so. So you would not be focusing on Section I there, you'd be focused on Section F in my view. I'm not going to go into too much more detail about EOTAS because my colleague Nicole has written about it in a lot of detail previously, and she has also done a webinar on it. But of course, if you do have any questions on that point, put it in the Q&A and we'll do our best to answer that as and when we can. So that's very much looking at an EHC plan in a little bit of detail. Now, let's presume that the EHC plan you're looking at doesn't come up to that level of standard, or the local authority has refused to name the school of your choice in Section I of the EHC plan. Or of course, the local authority may have actually refused your request for an EHC Needs Assessment, or they may have decided they're not going to issue an EHC plan. Your next point of call, in my view, is to consider an appeal to the SEN Tribunal. Now, that process is the same, whether or not that is for a refusal to assess, refusal to issue, or an against content appeal, or against cease to maintain, for example. What a key question I get from parents is mediation. And often parents will ask me, well, why don't we consider mediation? Do you think mediation is appropriate in my case, for example, and there is a requirement under the Children and Families Act for you to consider mediation, but you do not have to go ahead with it. Now, my advice usually to parents at this point in relation to mediation is that it's unlikely to get the result you want, because when you look at it for what it is you're asking a local authority to overturn a local authority's decision. In my view, you can already see the difficulty there with trying to do that. But also, if you are going to try and overturn a decision in mediation, you would probably expect to have new information to present to the local authority to try and overturn that decision. And if you end up delaying your mediation to try and obtain that information, or you wait as long as you possibly can to try and obtain that evidence, and then you try and seek to negotiate with the local authority in a mediation meeting, where the local authority still have the power to say, look, we've considered the evidence, but it's still a no. This may just drag out matters for an additional week or sometimes months. And I've also seen parents trying to negotiate with local authorities to avoid appeal for years. It really does happen in reality. An important point to consider is once you submit your appeal to an SEN tribunal, it does not mean you do not have the power to negotiate with your local authority. You still have plenty of opportunity to try and negotiate and get the local authority to see sense at that point. And what I also find through experience is that once an appeal is into the SEN tribunal, it does very much focus the local authority's mind, rather than outside in a mediation meeting where they still know that they have the overarching decision. When they know that there are deadlines approaching in the appeal, or that they may ultimately find themselves in front of a tribunal judge asking them what their case is, you may find that they actually do concede the appeal. And a lot of appeals do concede, and that is through negotiation once the appeal is ongoing. So it's not to say that you should ignore mediation. Mediation may work in some examples, but in general, my view is that you're best advised to submit an appeal to the SEN tribunal. Now, once you submit your appeal to the SEN tribunal, you are going to get a number of deadlines from the tribunal itself once they register your appeal. So the local authority will have to respond to your appeal, and that's usually around the 4 to 6 week mark. And they'll have to set out their case and say whether or not they agree with your appeal or whether they continue to oppose it, for example. After that stage is going to be the further information deadline, and that's usually around the 8th week of the appeal timetable. Sometimes that is going a little bit longer just because of the backlog of cases that the tribunal currently has. But at that point, you are going to have your case fully prepared. You are going to need all the evidence you seek to rely on in the tribunal ready to be served at that point in time. So it's really important that you start, as soon as you are thinking about submitting your appeal, to make sure that you are taking steps to get all of your information ready for that stage. And you can kind of guess when that's roughly going to be on the basis that the tribunal likes to operate on a 12-week timetable, which has currently been extended just slightly at this point in time. But as a general rule, that's what you're going to be working as, and that's what you should be preparing your evidence for and making sure you're going to have that all in time to submit it then. After that point, you are going to proceed to the hearing if the case does not settle before that point, which is when you will turn up to the tribunal, which will be done virtually now because they have moved all online at this point in time. Due to the COVID outbreak, that very much stemmed that, and it's now a virtual process. So it's going to be an online system where a tribunal judge will be on the other line, and a tribunal panel member, one if not two, will also be there, and they will be experts in their own right, such as former head teachers or even former educational psychologists, for example. And after that point where you put your case forward and the local authority will put their case forward, they'll have their representative, you may have your representative, you will have your experts on the line if you have experts. You will then get a decision after the tribunal hearing. You won't get a decision on the day, it will come after the tribunal hearing. So don't expect it to come out straight away, and it's usually about 2 weeks, but sometimes it can be more, sometimes it can be less. But it's just to make you aware that you don't expect a decision on the day as you might do in a criminal court, for example. So that's the sort of key elements of the tribunal process. But looking at some key points to help you when you are considering appealing to the SEN tribunal and how you're going to sort of navigate that tribunal appeal process. It's important to bear in mind that it is a formal court process. It is designed to be as user-friendly as possible because it appreciates the circumstances. This is decisions about your children, and it is very much geared up to help parents along the tribunal process. But it's still a legal process. You still have to make sure you comply with the deadlines. You still have to make sure you present your case properly. The tribunal is governed by first-year tribunal procedural rules and practice directions. The overriding objective of the tribunal is to deal with cases fairly and justly, and that's at Rule 2. What I would say is if you are submitting an appeal to the tribunal and you're currently going through them, it would be a good idea to have a look through the tribunal procedural rules, because it really does set out the process, and it sort of sets out the case management the tribunal has, and what might happen if things start going wrong in the tribunal, and what you should be looking at in terms of the procedural rules and how you might be able to navigate any problems. And you can find many answers in the procedural rules. So I would definitely have a look at those if I was you. What I would also say is the process is the same as I just set out. However, every case is different. There is not a one-size-fits-all approach in the tribunal appeal, because the legal test is individual need and what is necessary in the individual case. And the key issue is the critical mass of education provision required. What is it and what does it cost? So just taking a brief example about a refusal to issue appeal, and it was one of the questions sent in. So for example, if your child it's gone through the EHC Needs Assessment, but local authority has refused to issue the EHC plan, what you'll need to prepare your case on is what your child's needs are, what provision is required, and whether that goes above the level of what a school can typically provide through their own resources. Does that necessitate an EHC plan being issued? So at that point in time, you are going to need pretty clear evidence as to what provision is needed for your child, so the tribunal can decide on whether or not that does go above what a typical mainstream school can provide. So you would need your evidence to target that, and it would be a good idea to work out what that costs, because what is sort of typically held for a mainstream school is that they will have £6,000 to meet your child's needs out of their own resources. So if you can work above that level with targeting your evidence, it doesn't have to be on the basis of £6,000, but looking at that as a sort of practical example, then you would have a good chance of targeting your evidence to the point where the tribunal could say, yes, we agree an EHC plan is necessary here. When looking at EHC plan appeals, so the contents of the EHC plan, it does not matter what your EHC plan currently says. So you may be thinking, well, section B, F and I is pretty bad, because essentially what the tribunal can do is completely rewrite it. So you can have all of those sections completely rewritten. You could even potentially delete every single word within the EHC plan, within those sections, and it can be completely rewritten through what is known as the working document. And that is where you'll have an opportunity to rewrite your child's EHC plan, and that will be informed by expert evidence to form what should be included within the EHC plan. A common mistake we find with EHC plan appeals is that parents only ever submit their appeal about section I only. Now, if you remember how we just discussed how an how a EHC plan works and how all the sections have to interlink, then you would need to consider whether or not it is just a section I appeal. And a lot of the times it's going to be pretty pointless submitting a section I appeal only, when you really need to be looking at section B and F as well, because if the school is not meeting need, or if the school is wrong for your child, it suggests that the section B or section F, there is something missing in it, and you really need to be looking at what actually needs to go into those sections to then support the section I placement. Now, I will come on to a little bit more detail in a minute about how you would go about looking at the arguments for section I appeals, but it's really important from the outset of your appeal to think, actually, do I need to consider all of the sections? And if you do, you need to make your appeal on the outset on the basis of sections B, F and I. And you would do it at the outset with the tribunal appeal form. Just a final sort of practical point, it's considering requests for changes. Now, what requests for changes are is, once your appeal is registered, if you need the tribunal to look at anything, or you need to ask the tribunal to look at something within your case, you will likely need to put it on a request for changes. And so just as an example of that, so looking at that practically, so for example, if you get your hearing date and it does not work for you, for example, and you think, well, actually my experts now can't attend this date, something has come up in their diaries, you can look to request for change to get their hearing date moved in order for it to be a date that all your experts can attend and you can also attend. So there's also looking at whether or not the local authority is complying in your appeal. So, for example, you will see some local authorities don't take as much notice of these appeals as they should do. And what you can actually look to do is, if the local authority aren't complying with requests, so if they're not providing the information the tribunal may need, and you think they may have information they're withholding it, for example, you can make a request for the tribunal to say, look, you need to provide that information. If not, you're not going to be able to participate in these proceedings. And the tribunal does have powers to do so. And it's a good way of getting your local authority engaged, a good way of getting your local authority thinking about the appeal. And ultimately, it may end up getting you the evidence that you need from the local authority to really progress your case and put that in front of the tribunal on the day of the hearing. What you'll need to do is fill out Form SEN 7, and that's on the tribunal website. What you'll also need to do is ask the local authority for their views on the request, and that's really important because if you don't do that and you submit your request without the local authority considering the request, the tribunal will ultimately just send it back. And if you're in a bit of a timescale rush about trying to get this request in, you really do need to do that and avoid having the tribunal come back and say you need to go and consult with the local authority before doing this request. Now, looking a bit more as to what the cornerstone of your case is going to be and what is going to make up the really crucial elements of your case, SEND tribunals are very much evidence-based. So you need evidence that is appropriately targeted to your child, that is up to date and current. And by that, I mean looking relatively at sort of 6 months and no less. And what I mean by evidence, the sort of key evidence that you're going to need, in my view, is expert evidence to support your case. Now, you're going to need, ultimately, likely to need independent experts which are going to support you in the SEND tribunal and support what you are seeking to be put in the EHC plan, because the tribunal are very inquisitorial by nature, and they're not just going to accept your word on it in terms of what provision your child needs. Now, I don't doubt you as a parent knows what your child needs. However, in order to support your case with the tribunal, you are going to have expert evidence to support it as well. And usually that is going to need to be independent expert evidence. So if you are able to afford it, you are well advised to go ahead and obtain it. And what I mean by independent expert evidence is educational psychologists, speech and language therapists, occupational therapists, social workers, consultant psychiatrists, and there are many more. And what the SEND tribunal will do is consider independent expert evidence. So they can't just ignore that. They will consider it as equally as what they will consider local authorities evidence. And what you'll need to do is get those independent experts to carry out detailed assessments of your child, and they will then need to produce detailed reports, which you can then share within the tribunal and serve on the local authority, and then they can make up the sort of core of your case. And it really does lead to a successful outcome. Without that, you are going to be at a significant evidential disadvantage. And a lot of parents will say, well, can't we just rely on the local authorities and the NHS expert reports? Well, ultimately, often why you are here is because you've gone through the EHC Needs Assessment process, and the expert evidence which makes up your EHC plan, or which led to the decision for your local authority to say no to your EHC plan, is the experts that they have commissioned themselves. So your local authority expert, such as the educational psychologist, or you may have had an NHS speech and language therapist, for example, and they're often lacking the quantification and specification which are needed for your EHC plan, and they're not going to be good enough to get what you are seeking. And especially when you're looking at Section I appeals, for example, and if you're looking for a specialist placement to be named in it, which carries independent school fees, it's incredibly unlikely that your local authority expert is going to turn up and support your case. You have to remember that they are very much employed and commissioned by the local authority. And as a general rule, they're going to recommend what is in the local authority's budget and not necessarily what your child needs. So you really need to consider what expert evidence you have and whether or not you are going to need independent experts. And my view is ultimately you will need independent expert evidence, and that's going to give you the best chance of being successful in your SEND tribunal appeal. Looking specifically at your independent experts in a bit more detail, you are going to need your independent experts to be targeted to the needs of your child. So, for example, you can't have a speech and language therapist recommending direct occupational therapy sessions. You will need an occupational therapist to do so in order for the tribunal to name that in the EHC plan. This point is highlighted in bold because it's the most important point to take off this slide. Before instructing experts, you must ensure that the experts are willing to quantify their recommendations, willing to attend the SEN tribunal, and are familiar with the practice direction of the tribunal as to how expert evidence should be set out. Now, this is a really common point that we see with parents. They will have gone and got experts to support them, but actually before doing this, they didn't check as to whether or not those experts will actually attend the SEN tribunal on their behalf, whether they have any experience of doing SEN tribunal appeals, and whether or not their reports are actually going to comply with what the tribunal expects them to do so. And if they don't do those things, it's going to put you at very much a disadvantage, and you are going to be at risk of having done those reports. You then have to go to the SEN tribunal, and actually you then say to your educational psychologist, well, I need you to attend on that date. And actually your educational psychologist may turn around and say, actually, I don't do that. I don't specialise in SEN tribunal work, so I'm not actually going to attend on your behalf. That's not my expertise. Now, that's not to say they're a bad expert. SEN tribunal is just a very specialist nature, and not all experts do it. So it's really, really important to check before instructing your experts that they do all of those points. If they don't, you are really wasting your money at this point, because ultimately, if you need your reports in an SEN tribunal appeal, then you are going to miss out on that evidence because they're not actually going to be there to support you. And as I've stated already, they do need to be current and up to date. It's best to be within 6 months, and anything over that point is likely to be stale or out of date. So as a practical example, if you have an educational psychologist report which is 2 years old, that will very much set a benchmark for the tribunal to look at your child's needs, but it does not tell the tribunal what your child's needs are on the date of the hearing. And that is exactly what you're trying to tell the tribunal. So it needs to be as current and as up to date as it possibly can be. Now, there are other forms to consider away from just expert reports, but like I say, the expert reports are going to very much make up the sort of fundamentals of your case, but you can look at other sources of evidence. And so, for example, this is not an exhaustive list, but some key elements that I would suggest you consider is Freedom of Information Act requests. So you can ask your local authority specific questions about the provision they can offer, how much of it they can offer, and how much ultimately it's going to cost. So if you're making an argument about a specific school being named, and the local authority is saying, well, that's fine, we'll just add that on, it can be brought in by the school, you're going to need to know how much that is going to cost. And you can do that by way of a Freedom of Information Act request. And the local authority will have to come back to you within 20 working days of that request being made. And obviously you then need to consider that as to when you may get that back through your timescales, but 20 working days is the sort of general rule to apply there. Equally, likewise with that is data protection and GDPR requests. So you can send off requests to your current school, you could send off requests to the local authority, you could send off requests to the NHS, and they'll have to come back to you within 30 days with a full record of your child's, with the full details of the record they hold for your child. Now, within those requests, you can start to get really good information, and information that your local authority may not want to share with you. And there can be some really quite embarrassing points for the local authority when you start to see their internal records and their memos that they may have. But also, you can start to see what they're up to with their line of thinking with your child and what they're currently considering. So you can start to prepare your case around those points. And importantly, what you tend to find is that consultation records will come back, and you will get consultation records that you might not have seen from the local authority. And for example, I've been in many appeals where you look at Section I of the plan, and we're appealing that, and you send off your GDPR request and you get it back, and actually it turns out that the local authority got a consultation record back from the school they named in Section I, which actually sets out in detail why they're not suitable and why they should not be named. But the local authority have actually overridden that decision and included it within Section I. Now, of course, if you turn up to the tribunal with that piece of evidence, it's going to give you a distinct advantage over the local authority, who are going to try and keep on with that point in the appeal, because obviously it very much limits the suitability of that school being named. What is also important is the school records, so behavioural logs, incident reports, progress reports, etc. That can all go to show that the school is not working, or that increased levels of provision need to be put in place, for example. So looking at an EHC Needs Assessment request, you can see how that could be quite crucial, but also for an EHC plan where you're looking at additional levels of support, for example. And your own views are also very important for the tribunal. So you will have gone to your school, you know what your choice of school can do, you know what your choice of school can offer, for example. But importantly, you would need to go to your local authority school, have a look around there, and have a look through your own eyes as to what they can offer and how that correlates with your child's needs. And if that does not correlate with your child's needs, you just make a specific record as to the reasons why, and then you should really put those in your views as to why that would be inappropriate for the school to be named from your own personal perspective. And the tribunal will want to hear from you as parents in that respect. So it's really important to have a look at that and really have conversations with the schools and start to build that evidence up as to why that shouldn't be named in Section I of your child's EHC plan. And also records of conversations with your local authorities and schools, for example. If you are having phone calls, ask them to confirm it in writing, and anything that you think might be useful in that respect in terms of what they're saying about the level of provision that your child needs, then you should consider serving that within the appeal as well. Now, looking more specifically at Section I placement appeals, there are, generally speaking, two grounds in which you can be successful for your chosen placement to be named in the EHC plan. Now, this is a very sort of simplistic approach to look at it, but the arguments can be as simple as this. So the first ground that you could be successful on getting a school named in Section I of your choice is by demonstrating that the local authority's proposed placement is unable to make the appropriate provision for your child, and that your choice of school in contrast can. So your local authority cannot simply turn around and say to you, we know that our placement cannot meet needs, but it is cheaper, so that is all we are going to provide. The tribunal won't stand for that. The tribunal has to confirm whether or not that school is suitable to meet your child's needs. Now, of course, if it can't, then and your choice of school can, then you can be successful on that ground. The cost of the placement doesn't come into it. So your school may cost 4 times as much as the local authority's proposed placement, but if the local authorities can't meet your child's needs, then the cost of your placement does not come into play. The tribunal don't have to consider the cost at that point. It is just in relation as to whether or not it is suitable or not. So you really need to target your evidence in terms of whether or not your school is suitable and whether or not the local authority school is suitable. And you can start to see what arguments you will need to make. So you need to have really good evidence about your local authority's proposed placement as to why that can't meet needs, and then look at that in a lot of detail. The second ground that you should look at is the cost ground. So that if, for example, the tribunal accepts that both schools are suitable, then you need to be looking at what the schools cost, of course. So by exercising your right to parental preference under Section 9 of the Education Act, you have a right to parental preference being named in Section 9 of the EHC plan, subject to a basis of efficient use of resources, which at its most simplest put is if your school costs cheaper or as roughly similar in costing to the local authority, then you have a right to parental preference for that being named in the Section I of the EHC plan, and the tribunal can name it on that basis alone. Now, you would need good evidence to consider what the costs are of your chosen school, but also what the true costs of the local authority's placement are, so you can make your arguments around that point. What you need to consider is what the costings are, and that is all public expenditure. So that includes social care costs and healthcare costs. And that's really important to consider when you're looking at working day curriculums, for example, because if you do have an extensive package of social care provision in place, but for example, a working day curriculum would be able to take care of all of that provision, and it does fall into educational provision, you can then start to say, well, actually, you don't need to provide this social care provision anymore. You can put it all into one package, and that massively reduces your costs as a local authority. And now our costs for a working day curriculum start to come quite closer to each other, and you can make an argument for it. And if you also look at a sort of specialist independent placement for a specialist dyslexia placement, for example, if you're looking at what the cost of a mainstream setting is going to be to your local authority, then you need to include all of the costs of the provision. So, for example, if in a mainstream setting you would need full-time dedicated one-to-one support, but in a specialist setting such as specialist dyslexia setting, you don't need one-to-one support, then that is an additional cost to your local authority, and that has to be costed by the local authority, and that will have to be considered by the tribunal. Now, the cost of dedicated one-to-one support does not come cheap to a local authority, and schools don't just have one-to-ones laying around spare. So it's going to be an additional cost, and you would need to put that forward to the tribunal, for example. Looking more specifically at Section I placements and the evidence you would need, an important point there is a decision to name a school must be based on proper evidence. So you need to ensure that you have the proper evidence to make sure that the local authority can name that school in Section I of the EHC Plan. And that's especially important when you're considering independent placements, because the tribunal needs to be satisfied that yes, this is the right school to be named, and that decision has to be based on evidence. So as a minimum, you are going to need a signed provision place form from that independent setting, for example, confirming that an offer of place has been made and that the placement is secure until a certain date or until the tribunal appeal is finished, for example. You will need any Ofsted reports, any independent inspectorate reports. You will need detailed costings of the placement, what that includes, what that breaks down into. You will need an offer letter from the school setting out that yes, an offer has been made and yes, a placement is there. What you will also need to give yourselves the best chance of being successful, and this is often missing from parental appeals with Section I placements, is that you would need a report or a statement from the school setting out clearly how they intend to meet your child's needs. And that includes looking at what provision they are going to put in place, so what the peer group might be, what the qualifications of staff members are going to be, do they have specialism, what specialism is that, what are the class sizes, how is the therapy going to be delivered on site, for example, what therapy is delivered as part of the package. And then you need all of that to really apply to your child and really set that out in a detailed report. And that would give you the best chance of being successful with that placement. And that, like I say, that is often missing from parental appeals. And that can be really crucial for a tribunal deciding to name a school in Section I of the placement. A final point on placement appeals and what evidence you might need is it's really important to get your educational psychologist and get your expert to consider the school settings and really set out in their view as to whether or not it is suitable for your child, whether or not your choice of school can meet needs in their professional opinion, and whether or not, importantly, the local authority's proposed placement can meet needs. Now, if you've got an educational psychologist that hasn't been to those settings, it's going to give you a bit of disadvantage. So in an ideal world, you'll have your educational psychologist go to both settings. Now, in a post-COVID world, it is more difficult to get educational psychologists into schools, but it is still happening. But importantly, if a visit is not possible, well, get your educational psychologist to speak to the school, confirm in their view what they can offer, have a conversation, and really consider that within their reports, for example. Just because they can't visit doesn't mean they shouldn't have those conversations with schools. So that's very much, in a nutshell, how I would approach getting evidence to support a Section I appeal. As a benchmark, you should be looking to having a minimum of that evidence, in my view, combined with your expert evidence to really support your proposed placement to the tribunal and really give you the best chance of it being named in Section I of the EHC Plan. So looking after a tribunal appeal, and this is one of the questions that did come in before the webinar, you've got to look at timescales here. And a question was sent in, well, what are the timescales? What happens afterwards? Because the local authority has simply done nothing. Now, they are set out in the SEND regulations, and they are set out in Regulation 44 and 5. And you would need to look at the SEND amendment regulations as well. And essentially, if your appeal is about an EHC Needs Assessment, the local authority shall, within 2 weeks of the order being made, notify you as parents that the assessment is taking place. Within 10 weeks of the tribunal decision or the order being made, they will have to complete that assessment and tell you whether or not an EHC plan will be issued. Or if an EHC plan is agreed to be required, the EHC plan must be issued within 14 weeks. For a refusal to issue appeal, the local authority must issue a draft EHC plan within 5 weeks of the order being made. And then secondly, within 11 weeks of the order being made, you must be presented with a finalised EHC plan. Looking at the against content appeals, your local authority will have 5 weeks in which to make that EHC plan, and they will then have to give you a finalised EHC plan, and then your legal right for that provision to be in place is then in place at that point, once the finalised EHC plan is issued. Now, a specific question was asked, well, what about if we go to mediation? What are the timescales after mediation? And if you look at Regulation 42, subsection 2 of the SEN regulations, that states that if the mediation is in relation to one of the issues above which can go to appeal to the SEN Tribunal, the timescales following an appeal will apply. So you would be applying these timescales to your process moving forward. So it's something to consider. If you have been to mediation, that is what the timescales are. So that was a very sort of whistle-stop tour between what an EHC plan is, how you go about getting one, and what you can do in an SEN Tribunal. Now, this is very much looking at some common problems that I have come across with parents, and I come across regularly. And one of the key points is funding. So who is to fund my EHC plan? Who is going to have to make sure that this provision is in place? And the law is quite clear on this point, and it is Section 42(2) of the Children and Families Act, which says the local authority must secure the specified special education provision for the child or young person. So anything which is specified in your child's EHC plan under Section F, the local authority have a legal duty to comply with that and provide that and make sure it's delivered for your child. Now, there is no get-out clause for local authority when they do this, so they can't simply turn around and say that's too expensive, we can't deliver that, or we don't have anyone to deliver it. That's not going to wash. They have to make all the arrangements to put that in place, and there is case law to support that, which is set out on the slide. So looking at that, the EHC plan often actually makes reference to arrangements to funding, so how it's split between healthcare, social care, or education, or it may be reference to band funding, top-up funding, which the local authority says they've agreed with your school, and it's a certain level. However, such arrangements have no legal effect in terms of the child or young person's entitlement to the provision in the EHC plan, and the local authority remains ultimately responsible for making the provision if the school or the NHS fails to do so, for example. So just by the local authority putting in place saying, well, we've given your school £10,000, if they're not doing it, that's tough luck. Well, actually, no, you can turn around and say, no, you have a legal right to put this in place and you're going to have to do so. And if the local authority fails to do so, you can easily resolve that by way of a pre-action protocol letter. So looking at what tends to happen here and where there is a real issue between schools and local authorities, that the school will say, well, we haven't been given enough funding to deliver the provision, we can't provide that to you. You'll go to your local authority and tell them this, and they'll say, well, actually, we've given adequate top-up funding, it's the school's problem, they need to deal with that. And now the simple answer to that is that the local authority are under the duty to provide the special education provision, not your school. So if there is a lack of funding in place from at your school, then the local authority have to fund it. If the school are just being difficult, for example, well, that's not your problem, that's the local authority's problem, for example. So how the LA choose to fund the provision is really not your concern. You just need to be focused on the fact that you have a legal right to that provision. Now, what is happening in a COVID world we are seeing is essentially what is still in place is that duty. In the first lockdown, that was reduced temporarily by COVID amendment regulations. However, the legal duty under Section 42 is now back in place in full, and it has been since the end of September. However, I've seen on social media, for example, that local authorities are actually trying to say that they're not operating under Section 42 at this moment in time, and it's gone back down to the reduced duty, which was a best endeavours approach. Now, that is not the case. Local authorities are still under a duty under Section 42 Children and Families Act at the time of speaking, to make sure that provision is provided. It has not been lessened since that's been rescinded by the government. So if they do try and tell you that is completely wrong, and you could look to enforce that under Section 42 of the Children and Families Act. Just another point, which is kind of in relation to funding as well, and parents will often say to me, well, I'm considering a personal budget for my child's EHC plan, or my local authority have given me a personal budget to go out and secure the provision in Section F of the plan. And now often difficulties can arise from that. But under Section 49 of Children and Families Act, you do have a right to request a personal budget, and the local authority will consider your request for a budget, and usually by way of direct payments, the local authority will give you a sum of money to go out and provide that, go out and secure that provision in Section F of the EHC plan. And personal budgets are governed by their own regulations. The educational ones are dealt by the special educational needs personal budget regulations. There are different regulations for healthcare provision and social care provision, for example. So you're already potentially dealing with 3 different sets of regulations there. What I would say is that difficulties do arise in relation to personal budgets, and the common difficulties that I do see, and we do see as a practice, is that if you do agree personal budgets and difficulty arise organising provision, you cannot appeal to the SEN Tribunal to have that personal budget sorted out. You don't have a right of appeal against the personal budget, and realistically your next opportunity to challenge would be an annual review, or you could look to call an emergency annual review, for example, against that, but you don't have a specific right to appeal to the SEN Tribunal. Now, once a personal budget is agreed, it may not actually cover the true cost of the provision. Now, this is something we find time and time again where personal budgets are agreed, and whilst the local authority have to provide sufficient enough payments to make what provision is within the EHC plan, if it does not in practice do that in terms of what you can actually get on the free market in terms of trying to secure this privately, you may not have recourse against your local authority to make up that shortfall. So, for example, a classic example is one-to-one support. So you may have to go out and fund the one-to-one support yourself, and that's what you might want to do. However, your local authority may have given you a sum of money on the basis that you're getting a teaching assistant on the bottom end of the pay scale, for example. But actually, in fact, you need a teaching assistant which needs more experience of working with SEN children, and actually they're towards the top pay scale. So therefore, you may have a shortfall of £3,000, for example, and actually local authority may quite rightly turn around and say, well, actually, we've given you enough for one-to-one support. Here is the one-to-one support. You could go out and get that. We're not going to give you the money to go out and get the absolute best one-to-one support. And of course, that is subject to what your EHC plan says, but in practice, that can leave you short, and that can leave you out of pocket in that example. What can also happen is that personal budgets become unnecessarily complex because payments may be needed for education, social and healthcare, all of which are governed by their own regulations, and you are set aside trying to deal with this yourself rather than letting the local authority have to deal with it under Section 42. Now, that is something I would always make aware to parents when they are considering these personal budgets. It's that the local authority are on a quite clear duty to go out and provide that provision. Now, you may have doubts about whether or not the local authority will actually go out and do that, but if they don't, you have a it can be easily resolved through way of pre-action protocol letter, because the legal duty is so clear that the local authority must provide that provision. You really don't have to concern yourselves as to whether or not that provision is going to be put in place, because you can rectify that through pre-action protocol correspondence. So if you're doing it out, agreeing to a personal budget out of fear, for example, the local authority not doing what they should do, this would give you would be best advised just to leave the local authority to get on with their duty, and if it goes wrong, you can seek to have it rectified through a pre-action protocol letter. The next point that is a common point that I speak about with parents is transport. Now, transport is a unnecessarily complex area of law, and the law very much changes depending on the age of the child or the young person and their needs. Now, when you're looking at your child's entitlement to transport, that does very much depend on the age. So, for example, children of compulsory school age, 5 to 16, there is a clear compulsory duty on the local authority to arrange free suitable home to school transport for children of compulsory school age who are eligible to the nearest suitable school. Now, when we're looking at that in the EHC plan context, your child will be eligible for that on the basis that they have special educational needs. When we're looking at the fact of what is the nearest suitable school, well, if a suitable school is named in Section I of the EHC, if a school is named in Section I of the EHC plan, then yes, that is the suitable school, and that is held to be the nearest suitable school. So at that point in time, with an EHC plan naming your choice, naming the school in the EHC plan, the local authority are required to provide transport for your child, and they are required to do it for free at that age. Now, once you start to go through the age groups, that duty does start to lessen. So for over compulsory school age but under 19, the local authority must publish a transport policy statement for persons of sixth form age, which specifies the arrangements the authority considered necessary. So that is not an absolute duty for transport. It is up to what is considered necessary. Now that is the same for young persons between the ages of 19 to 25, which still need to attend college or further education establishments, for example. And again, the local authority must consider what is necessary in those circumstances. When we are looking at necessary, the local authority has to consider what is necessary and should do this on a factual basis and in good faith. And if it is considered necessary, then the local authority must provide it for free. So that is a very sort of broad set out as what the transport requirements are for the different age groups. Now, as you can see, the stronger duty is there for children of compulsory school age, and that's quite clear. Anything else, you're looking at what the local authority considers necessary, but with EHC plans, it does tend to get more sensible responses from the local authority. Looking at sort of common issues we have with transport, common issues I find with parents, for example, when dealing with transport, local authorities have a duty to provide you with transport to and from the school named in Section 9 of your child's EHC Plan 16, and when it's compulsory school age, failure to do so is unlawful. Now, often parents have come to us with local authorities refusing to comply with this duty, or actually putting wording in an EHC plan which seeks to limit the local authority's duty. For example, Section 9 of an EHC plan stated, a place in a special school has been awarded at Gove Bridge, although excess needs could be met in borough. The LA are agreeing to name Gove Bridge as per parental preference, but the responsibility for transport now falls on the parent. Now, wording such as this is not the correct legal test for local authority, and that's not what the law prescribes. So wording such as this is potentially unlawful. Now, local authority can suggest to you that you do provide transport on the basis of naming your preferred school. That is a perfectly legal approach for local authorities to take. However, in this example, which was a real client of mine, the local authority had put this in without agreement from the parent. The parent had never agreed to this and had never entered any discussion about the local authority doing this. They simply just done that and then expected the parent to transport their child 20 miles to and from each day to the school named in the EHC plan, which was just unworkable for the parent. And we successfully overturned that with a pre-action protocol letter, and the local authority soon backed down and removed that wording from the EHC plan and put the necessary transport arrangements in place. So look out for that if that's in your child's EHC plan, if it's not been agreed to, is what I would say there. Next point to consider on transport is that transport is from the home address to school and back. Often parents are asked to take their child to a drop-off point or similar, but if that doesn't work for yourselves and you are entitled to transport, you don't have to do that. And it's important to remember that transport must also be suitable. So looking at your child's needs, do they need individual transport? Do they need an escort with them? Is all important considerations the local authority must make. The final point I would raise on transport, and it's looking more of a practical point rather than any sort of legal point, is that transport can be key in negotiation with your local authority, especially within a tribunal appeal, for example, because the cost of transport do come into play. Now, for example, if your transport costs to your parental preferred placement are high, you may want to consider transport, but in no way do you have to. But for example, if you think, well, actually, no, I want to transport my child and I can make that work, you may want to consider that as part of any negotiation with local authorities, because ultimately that's going to cut their costs down, because local authorities do spend a significant amount of money on transport. So if you can reduce that cost, it reduces the overall cost of the package of your parental preferred choice, and the local authority may well take that. So that is what I would say in relation to transport in a very general sense. Now, of course, other difficulties do arise in transport, but that's sort of the key points that I come across. The next point that is also very common for parents with SEN, with children with SEN, because statistically, children with SEN are far more likely to be excluded from mainstream schools. It happens across the country, and children are being unlawfully excluded, and in some instances are actually being off-rolled from the school. Now, what I mean from unlawful exclusions, for example, is your school asking you to collect your child for him or her to cool off, and where that's not actually recorded as an exclusion on their formal record is unlawful. A decision to place your child on a part-time timetable without your agreement is also an unlawful exclusion. So where schools may say to you, well, we can't meet needs, you're going to have to take them home in the afternoon in order for us to be able to continue having your child here. That is completely unlawful to do so. Off-rolling, for example, is removing a pupil from the school role without using permanent exclusion, when the removal is primarily in the best interest of the school rather than the best interest of the pupil. So parents are being faced with incredible pressure to find different schools, move to unsuitable placements, and even pressure to electively home educated by their school. If not, the school will permanently exclude the child. Now, that is a situation which should be avoided, and it is not necessary. Importantly, you need to consider carefully where there is pressure to electively home educate, because that needs to be avoided at all costs, in my view, because electing to home educate your child can absolve your local authority of their duty to provide the provision within the EHC plan. They don't have to provide that provision if you have electively home educated your child. And now, this is not to be confused with education otherwise at school. That is a separate point. That is where it's set out in the EHC plan that your child should be educated otherwise at school. Elective home education is completely different, and like I say, that does need to be avoided because it does absolve your local authority of providing the support that your child needs in the EHC plan, for example. Importantly, schools can't exclude for reason that they are unable to meet your child's needs. It is unlawful for them to do so, and unlawful exclusions can constitute disability discrimination under the Equality Act. Now, Melinda is going to be doing a webinar about discrimination claims, disability discrimination claims, so I'm not going to go into too much detail. However, if it does happen in your school, it is excluding your child for unlawful reason, or the fact that they can't meet needs, then you would have a right to challenge that under disability discrimination under the Equality Act. You also have a right to challenge exclusions through the formal process. However, what I want to consider is whether or not the exclusion is the be all and end all, and whether or not you want to be scared of that as parents, and what that may mean for you as your child in terms of the provision they receive. Because what local authority maintained schools have to do is follow the statutory guidance for exclusions. And what that says at paragraph 3.22 is that head teachers should consider what extra support might be needed to identify and address the needs of pupils in order to reduce the risk from exclusion. Paragraph 3.25 is that if there are concerns about behavioural risk of exclusion for children with SEN, it should consider what additional support is required. This should involve assessing the suitability of provision for a pupil's SEN, or if an EHC plan is in place, an emergency annual review. So you can already see under paragraph 3.25 that actually that could kickstart an EHC Needs Assessment process if your child is at risk of being excluded, for example. It suggests the current provision is not working and something needs to change, and an EHC Needs Assessment is required to ascertain what that is before the exclusion is made. Further, if your child does have an EHC plan in place, if your child is being excluded for reasons which are potentially unlawful, or if there are difficulties happening in the classroom, that would suggest an increase in provision may be needed as well. So the formal exclusion process will provide a process of review and crucially triggers duties that ensures a child's provision is considered and is often increases in the level of provision. So rather than parents being very intimidated by this process of exclusion, which quite rightly so, it's never nice to hear that your child may be excluded from school. And of course, there may be completely unlawful reasons for the school doing this. However, when you look at this in terms of the statutory guidance for exclusions, it can also help with what you are currently seeking. So for example, if you are seeking a placement at a specialist school, but the local authority says you do not need that, is working at the mainstream school. If you've got evidence that your child is about to be excluded, for example, that is very good evidence that that is not working for your child, and that would support your case. Likewise, with EHC Needs Assessments, if the child is at risk of being excluded, as the code says, it suggested that an EHC Needs Assessment is required. So you could actually use the evidence within an exclusion to your gain, and that could actually support your appeal process, for example, or support your EHC Needs Assessment application. So it's just important to be aware of those points and not to be completely alarmed and completely panicked when these things do happen, because ultimately you can use it to your advantage to get the support in place for your child. Now, that's the sort of common problems I come across with parents. Now, the key issue then becomes, well, what can we do about it? And that is a very key issue. What can you do about it when it does go wrong? Because when you look at if you're happy with the contents of the EHC plan produced, or the school named in the plan, or the LA's decision not to assess, you have a right of appeal to the SEN Tribunal that's set out. However, when LAs fail to provide what is in the EHC plan, for example, or they do not give you a decision after your EHC Needs Assessment request, then you do not have a right of appeal to the SEN Tribunal against that. Likewise, with the other in-between points we've just gone through, there is no right to appeal to the SEN Tribunal to have this resolved. So therefore, you need to consider what you can do. Now, further examples of that, where you don't have rights to appeal to the SEN Tribunal, are provide you with a decision following the EHC Needs Assessment, unlawfully provide transport, failure to provide the provision within the plan, failure to provide an EHC plan within 5 weeks of a tribunal decision, for example. There are many more examples, but just some key ones on the slide. Now, what can you do about that? And generally, there are 3 options available to you. You can complain directly to local authority through their complaints policy. You can use the local government ombudsman complaint, or you can consider judicial review action. Now, in relation to the first 2 there, my view on those is that in the circumstances such as set out just a moment ago on that previous slide, they're not going to be much use to you getting what you need in a relatively quick time. Local authority complaints policy can take many weeks to go through, and it often doesn't get an actual decision from them, and it can take months. Likewise, with local government ombudsman complaints, you can spend months waiting for a decision, and it does not get you what you need in any sort of time frame that is appropriate to your child's education. So really, judicial review is the most appropriate in my circumstances in most cases. And what judicial review is a mechanism for the administrative court to review the lawfulness of a decision or an action made by a public body. Now, when you're considering judicial review proceedings, I don't have the time to go through what judicial review proceedings are in full detail. However, the first step, what you need to be aware of, is what is known as a pre-action protocol letter. The pre-action protocol letter is a formal legal letter which will go to local authority's legal team and the Director of Children's Services, setting out the alleged breach or what the local authority has failed to do. And the local authority will have to respond within 14 days. Now, that can be shortened in more urgent circumstances. And what you are going to get from the local authority is a response, and they are either going to have to set out why they do not agree with your pre-action protocol letter and what you're alleging has happened, or they're going to confirm to you, actually, yes, we know we should have provided you with that decision, here you are, and that decision is in place, or yes, that provision is, we haven't put that provision in place, this is what we're going to do, and that's going to be in place in a couple of days' time. That is generally what happens with pre-action protocol letters. And importantly, you don't need to have exhausted all the local authorities' complaint policies or the local government ombudsman to submit a pre-action protocol letter. You can do this before you have to do so. What is going to happen with the pre-action stage is that 9 times out of 10, you are going to get what you are seeking to resolve resolved through the pre-action protocol stage. The vast majority of cases will be resolved at the pre-action stage, and it is very rare for judicial review proceedings to be issued. Now, that is something to be aware of, because you need to be able to be aware of how you can enforce these decisions and how you can go about rectifying the local authority. And the pre-action protocol letter is a very important tool that you can use at your disposal to get this relatively resolved quite easily and quite quickly. Now, what I would say is that the judicial review is a complex legal process. Now, I would not advise you to embark on that without considering it properly, and I would certainly advise that you would need to take legal advice in relation to pre-action protocol letter and your judicial review proceedings itself. But it's important to remember that that is going to be one of the best tools that you can have for enforcement of these decisions. Now, that is very much it from me. It is a sort of very much whistle tour through those various points. I can see that there's a lot of questions coming through. So I think I'm going to hand over to Hayley now, and you can have a break from hearing my voice for a minute or two, and then we can go through as many questions as we can with you.
Hello everybody, just to give a bit of an update, because I appreciate there's more parents now than there were at the start of the webinar, and because I'm sure you like hearing my voice rather than James's, just to recap on some of the things we said at the start. Firstly, thank you for giving up your time to spend the evening with us on this webinar. It is now 25 to 9, so I appreciate on all of our marketing it was 7 till 8 p.m. and some of you have had to go off to put children to bed, etc. So please don't worry if you have got other commitments to go on to. As I said at the start of this webinar is being recorded and will be made available to you on all of our social media channels, so Facebook, Instagram, Twitter, LinkedIn, and you will also find it on our YouTube channel. So if you go onto YouTube and type into SEN Legal, you will find this recording, and you will also find the recording of all of the webinars that we're producing. So there has been 2 so far, and James is this evening, and obviously there is another one next week which is on the funding of EHC plans and recovery of funding for schools that Richard is running. So if you have missed any, please do go back and watch the recordings. And like I said, thank you, although we have overstayed our welcome somewhat. We love talking to parents. It's what we're absolutely passionate about. Anybody who works in our company has to be passionate about supporting families of children with special educational needs, and that is why unfortunately these events of ours always overrun, because we're always so keen to speak to you. So apologies for the overrunning. In terms of the questions, Richard and I have managed to get through 98 questions on the Q&As. Wow. Yeah, there's a lot, James. There are 56 still open, so Richard is busy in the background trying to get through as many more of those as he can. I have flagged a few that we'll go through live, James, in just a second, because they're kind of key questions that I know we hear on a daily basis, and I think they're some of the things that we can really confirm to parents what the actual answers to those are, because that's a lot of misinformation out there. So we'll go through them in a moment. In relation to some of the other kind of themes of questions that have been going on this evening, anybody who's asking about fees, we don't have a legal aid contract, unfortunately. We are a privately paid practice for parents and for schools. We don't represent local authorities, but we are privately paid, so you know there is a fee associated to our service. If you obviously do want support and can afford a solicitor, by all means, you're more than welcome to phone up our friendly team and get all details on our fees. Obviously, go to the SEN Legal website. You can submit an online form or call us up or send us an email. It's absolutely fine. The reason we hold these webinars is that so everybody can get access to the correct legal information. So if you unfortunately can't afford a solicitor and your financial budgets don't they don't go that far, please do watch the webinars. I had a lovely conversation with a lady earlier on this week who told me that she watches the webinar, she shares it with her parent groups. That is what we ask of you, because it's just so important to us that parents know their rights. So even if you can't afford to go to a solicitor, please do share this information. It's really important that it gets out there and the information gets to as many parents as possible. On that note, if you are leaving the webinar while we go for these last kind of few questions with James now, please make sure you leave us your feedback. You can obviously speak to us in the chat function now just to say what you thought on the webinar. Please also come back to us on any of the social media platforms. And as I said, I am director of the company. I make sure I listen to all of the feedback we get from parents. We try to make as much free content as possible for you. So I am very much guided by the information you give back to me. So please do feedback to us and let me know what you think we should be doing topics on and what you think is helpful. And we will always listen to that and produce as much content as possible for you so that we can support parents. That's why we're here. That's why we have this practice. So in terms of the remaining questions, James, if we may.
Yeah, of course.
The first one is talking about if an EHC plan content has remained unchanged, including outcomes for over 6 years, and the child has not progressed, should the provision now need to be made up to make up for the lack of provision, progress and regression that has resulted in an inadequate plan? And should this be part of any assessments done? Now, I'll let you answer the question. These kind of questions really annoy me because annoy everyone that works with me, because 6 years this child has gone without adequate support, and that is not acceptable. So if there are other local authority members watching this, and I know some local authorities do watch these webinars, do not let this happen in your local authority. This is just not acceptable. An annual review should contain updated outcomes every year. And James, I don't know if you want to talk about that. I just wanted to share my anger at this situation that we obviously hear a lot.
No, that's quite a shocking state of affairs, that's for sure. 6 years is completely unacceptable there. And like you said, there should be an annual review process going on each year where the outcomes should be looked at, whether they remain appropriate, and subsequently whether or not the provision remains appropriate. So what is undoubtedly needed is a review is going to be needed as soon as possible. And if the local authority is still saying that they're going to refuse to do that, for example, you would be called an emergency annual review, and you would seek to have that. You would want a reassessment of your child's needs. I would say at this point in time, if it's been 6 years since it's been updated, and you would want some current evidence as to what your child's needs are, bearing in mind the lack of provision that has gone in place. So realistically, the provision that can be put now into the EHC plan moving forward can be targeted at making sure that the child does now catch up, and it is now appropriate on her needs on the current date. So yeah, I would certainly say a reassessment of needs is going to be needed, and you can look to have provision to help catch up. For example, an educational psychologist may confirm to you that it's in their view your child should repeat a year to try and catch up, for example, and that can be put into the EHC plan for your child to repeat a year. And ultimately, you would want all the provision now put back into the plan, and for it to be as current as it possibly can be, to make sure your child's needs are met moving forward. And of course, the EHC plan, depending on the age of your child, but it can still go up to 25, so you can still have a considerable time of that provision being put in place. So yes, the provision should be looked at, and yes, it should be updated as a matter of priority in my view.
Okay, thanks, James. This one goes right back to refusals to assess, which obviously we see on a daily basis. And I'll talk to this a bit as well. It says, "Hiya, I have had a refusal to assess for an EHCP stating that they agree my son has SEN, but that the school needs to do more to support him. How do I argue this? At mediation, they said bring more evidence." Now, for anybody who's not familiar, the person who's written this, I assume they mean they've had a refusal to assess for an EHC Needs Assessment, not an actual EHC plan. That sounds like what's going on here. This is a very standardised letter, to the extent that we will get the exact same letter from some local authorities with just the name changed. The child's name has been changed and the exact same letter is issued. So this, the school needs to do more to support him, needs can be met at SEN level, needs to seek EP support, EP referral, etc. They're all just standardised reasons that the local authority has issued. And it seems very negative for me to say that, but I genuinely believe it's a cost decision, because if a local authority refused 10 applications and only 3 parents appeal, then they've saved money on those other 7. And I know that sounds, very negative, but obviously this is our day in, day out, and it's what we see on a daily basis. Parents should always appeal if they're able to, even if they're not using a solicitor. Something that's really misinterpreted by local authorities: parents win an awful lot of the time at tribunal. So please don't be put off going to the tribunal. Just by way of an example, we revealed our success rate for last year, 2020, and our success rate was 98%. That's not to say we're amazing. That is just to say that when things are done properly, local authorities often make a lot of unlawful decisions that, when legally challenged, come up in the parent's favour. Even when you're not looking at our success rate, I believe it's about 86% parents are successful at the tribunal. So that just tells you how little local authorities win when you challenge these decisions. So if it seems dodgy, if it doesn't seem correct, it's probably not. And do obviously seek legal advice, get legal aid to challenge these decisions. Please, please, please don't be put off going to tribunal to challenge them. So on the basis that's something we hear all the time, James, this parent is obviously asking, how do I argue this? Because at mediation, they've just said, bring more evidence. And obviously our advice would just be to appeal. Do you want to talk more about that and refusal to assess?
Yeah, so obviously, ultimately, I would share your opinion there that yes, we should go to an appeal on that point rather than mediation, especially with an EHC Needs Assessment refusal, because when you start looking at that within the tribunal, a lot of those cases will settle, and sometimes you'll get a response from local authority as soon as the appeal goes in, and they'll come back and say, yes, well, we've reconsidered, and you're right, here comes the EHC Needs Assessment. However, if you're going to try and do that in mediation, what I think you need to really drum through to local authority is that there is a very low threshold for this to be granted. You do not have to have evidence that there is, you do not have to have evidence, you don't have to bring with you further evidence that they're trying to make you required to do so. what you need to focus on is the legal threshold, which is a balance of probabilities test. And I would focus your arguments on that and really setting out that point. However, if you do have any evidence which suggests your child does need specific provision, for example, I would certainly take that with you to give you the best chance of being successful at the mediation meeting. But I think, like Hayley said, it's probably a blanket policy that they're just trying to apply, and they've probably sent out a few of those on the day that they sent out to yourselves, for example. So ultimately, you need to make the arguments on the balance of probabilities test and really just set out that it is a low threshold, in my view, if you are going to do it by mediation. But I would certainly advise that if you are in two minds about the mediation and it's what the local authority suggested, for example, I would just circumvent that and go straight to an appeal, in my view.
Thanks, James. Something that I think parents also need to be aware of, and we hear this an awful lot. This is from an anonymous attendee, but it says, sorry if this is about to be covered, which obviously I'm not actually sure if James covered it because I'm so busy furiously responding to your questions. But it says, does a EHCP request only apply to a child with academic SEN? So this is the classic, my son has just been diagnosed with Asperger's. So academically, his needs are very little, but does need the social, emotional, sensory and support in getting his knowledge onto paper, if that makes sense. That makes complete sense to us. And it's very, very common with obviously children with Asperger's, as we know. So these children are academically very, very bright. And often you see the meltdowns at home, and James and I get this from parents all of the time. They get the behavioural outburst or the meltdown type behaviour because they've bottled it up all day at school and are coping, and then suddenly you have them home in the evening, and when they feel comfortable and secure in that home environment, you will see those behaviours. You can absolutely document that. And many local authorities try to put parents off applying in that scenario because they will say, well, they're doing fine, they're top of the class. There is a section of the Code of Practice, it's 6.23 in the Code of Practice that specifically provides for this, and tribunals have been known to quote it in their decisions as well. If your child is displaying these behaviours because of the anxiety, because of the build-up all day, document it. So you can put it in a home diary, you can put it in a communication log, you can certainly put it in your parental views. That can all form evidence of a need for an EHC Needs Assessment. I don't know if there's anything else you'd want to add to that question, James. We see this quite a lot, don't we?
Yeah, no, I think that's absolutely right. And yeah, I did put the point on, I can't remember what specific slide it is, but it's looking at the common myths. So yeah, that exactly what you said. You'd look at the Code of Practice there, and it's actually, that is one of the more helpful aspects of the Code of Practice. And you would quote that directly to the local authority and document it like you say. So yeah, I'd agree with that. We've
got another unlawful question here, so I'll read this out to you to respond on. In section F, can local authorities put time limits on provision? For example, until July 2021, X will require the following speech and language therapy. In a new setting, X would require a review of his speech and language therapy. Suggestions that this has to be done by a certain time, or there'll be a need for a further assessment in obviously another setting. Obviously unlawful. I'll let you answer that. Yeah, and like you say, it is unlawful. There's no timescale on the provision. What should be happening is an annual review, and if it remains appropriate, it stays in the plan. There's no set timescales on it. And I think if you look at the one of the points that I didn't go through for the examples of bad EHC plans, but they actually, it's an EHC plan that we came across quite recently. There was a time limit on the teacher of the visually impaired provision being in place when the child had a visual impairment. Now that said, at the age of 16, it needs to be considered whether or not that should remain. Well, of course, with a child with a visual impairment, we don't really see local authorities reason as to when that's going to get better at 16, for example. And of course, it does make the wording completely unlawful. So that would be a challenge to the SEN Tribunal, and the Tribunal would ultimately agree with that point, in my view. The final question we'll answer live, because obviously I'm just cautious of the time and needing to get little people to bed, and obviously go and relax yourselves. I appreciate it's very full on for parents, so we don't want to take up any more of your evening. We'll answer this final question live, and then we will remain on the webinar with obviously our cameras off and our mics muted to answer as many more questions as we can until 9 o'clock. And then at 9 o'clock, we will end tonight's webinar. And like I've said, do come back to us with your feedback, engage with us on social media, and we'll do as much as we can to bring you further content in the future. So the final question that we're going to address live is from Natasha. If you haven't seen the Preparing for Annual Reviews webinar, you might want to go back and have a look at this, because this is again example of the local authority watering down provision, making it less specific, less quantified, and ultimately reducing the content in an EHC plan. So the question is, James, what is the difference between direct and dedicated one-to-one TA for unstructured times and direct and dedicated TA for unstructured times? So they have removed the one-to-one bit. This was what the local authority changed the wording to in section F of my son's EHC plan and annual review, based on the fact the school were not currently providing a one-to-one just for my son, so decided it wasn't needed. And that's essentially the question. They've removed the actual one-to-one and just said ATA rather than a direct and dedicated TA.
Well, I think the reason they've done that is obviously based on what the school have told them, and that's a completely wrong approach from the local authority as well. It shouldn't be based on what the school can actually deliver. It should be on what your child needs. So the fact that they've done that and lessened the wording within it suggests to me that you're not going to find that you're going to be provided with the one support your child needs. And that's probably due to some form of resources, because the school may have said, well, we can't keep affording this dedicated one-to-one support, which means they will be with your child when they are needed, for example, throughout the lessons. So it probably suggests that it's a funding point, but essentially the local authority shouldn't be guided by funding. It should be what your child actually needs, and the fact what the school can provide shouldn't be considered there. It's what your child needs. So it's not the correct position for local authority to take, that's for sure. And it's one that could be challenged in the SEN Tribunal again when you come to look at it. But if it is one that you could very much put to the local authority and say, well, that's completely inappropriate because the one-to-one support is still required. It's just a lack of resources, meaning this has been changed. But of course, if you don't get anywhere with your local authority at that point, you would need an appeal to the SEN Tribunal to get the one-to-one support back in place, unfortunately.
Thanks very much for that, James. So just to obviously remind everybody, we will now stay on the webinar until 9 o'clock. We've got 10 minutes for Richard, James and I to jump back on the Q&As and try to get through as many more of them as possible. And at 9 PM, we will be ending the webinar. We do have to have a cut-off point, because genuinely we would sit up all night talking to you all, which will be lovely for you, but we don't actually get hardly much sleep at all. So we do need to obviously sign off at some point, but do feedback to us on our social media. Please let us know what you think of the webinars. Please feedback to me so that we know what content to provide for you. And we'll jump on to the question and answers for the last 10 minutes. I really hope you found tonight's webinar useful, and a reminder of the next event for schools next week in terms of funding, and to recap on all of the ones you've missed if you've missed them so far. Thank you so much, and we look forward to you joining another event very, very soon. Thank you.